Call the third case on this morning's docket, case number 118188, in the matter of the guardianship and conservatorship of BH, DD, SD, and BD minor children.
May it please the court, my name is Andrea Hughes, and I am here on behalf of the appellee guardians, and I am ready for argument.
Council may take their seats at the tables.
John Gillette on behalf of the natural parents, Sam Dixon and Alicia Dolly, and they are both present.
Very well.
Charles H. App III, Your Honor, guardian ad litem for the minor children.
Very well, thank you.
May it please the court. Good morning. My name is Andrea Hughes. I appear on behalf of the appellee guardians, and I would like to reserve 5 minutes for rebuttal.
5 minutes is granted.
This case comes before this court as a result of 4 prior cases over the last 8, nearly 9 years. 4 interrelated child in need of care cases began in August of 2010. A probate guardianship matter regarding those children began in October of 2010. These cases were concluded between December 2010 and March of 2011. The guardianship of the children remained with the appellees until today. They're still with the guardians. In June of 2016, the natural parents petitioned the district court and the probate to terminate the guardianship established by the 2010 cases. The trial court denied that termination of the guardianship, and the natural parents appealed to the appellate court in December of 2017. The appellate court reversed the 2016 trial court's decisions and remanded it back to the district court with the directions to terminate the guardianship in a reasonable time.
Can you talk about the interplay between the child in need of care petition and what was found in the child in need of care case? Because I understand the children were designated as children in need of care at the time it was filed during that proceeding, and then the probate proceeding. What was the interplay of those two different court actions?
I'll go by the history of the dates, if you don't mind, Your Honor. In August of 2010, law enforcement took the children into protective custody, and in September 1st, child in need of care petitions were entered for the children, and temporary custody was issued to the guardian, the Botnicks. In October of 2010, that same year, October 4th to be precise, orders of adjudication were entered in the child in need of care case under KSA 38-2202 D1.
Were there any, in the sync proceeding, were there any kind of permanency plan, any kind of intervention done that is typically done in the sync case, or was that all just kind of circumvented by the probate guardianship?
It wasn't quite circumvented. While the probate guardianship started 10 days after the adjudication, there were referrals to family services on the adjudication date on 10/4/2010. Those referrals subsequently produced at least 3 reports that I was able to identify. One on October 24th that was filed with the court on the 27th. And that was basically the family services report indicating that they had gotten the referral from the adjudication and they were beginning the process. There was an additional family services report in December 8th of 2010. And finally, the reintegration plan was actually filed by Family Services in January, but at that time, the probate matter had already concluded. However, there is a caveat. Actual orders and journal entries were not entered in any of this, in the majority of the SYNC cases. One case, there was a journal entry review of hearing, and in that case, the child was released from SRS custody, actually journaled in the SYNC case. However, we do not have that same journaling or orders in the other SYNC cases before you today. That only happened in case number ending in 7.
So does that mean those other children remained in SRS custody?
The judge that presided over the SYNC case also presided over the probate matter case, the consent to guardianship case. In his notes regarding the SYNC cases, he does note in his minutes that he will be terminating the cases upon acceptance of the probate matter consent to guardianship. But it does not translate into an order. That was on the record.
And the concept was because they were under Chapter 59 guardianship, that they were no longer children in need of care? Is that what the thought was?
The specific statute that they cited to create the child in need of care was was 382202 D1, that the children were without adequate parental care. That was the adjudication on October 4th, 2010. And I believe that the judge in both matters misidentified the interpretation of the need for the child in need of care statute to be the final authority over that adjudicated children in need of care. And he perhaps erred in deciding that could simply be resolved by giving parental care to the children through a consensual guardianship. But that's what brought us here today, is that tore apart the framework of the child in need of care statute, in that it took away the permanency, the nature of the statute to be the binding authority over children adjudicated in need of care.
What do we do with that? How do we resolve that? Because it seems to me that this ought to be in the Chapter 38 arena. That's what SYNC proceedings and what are designed to do, to address the very questions that the court maybe or maybe not found to be extraordinary. We can talk about those in a little bit. But aren't we in the probate court is not set up to do this?
Yes, Your Honor, we completely agree. We believe that not only did the probate court in 2010 error, and not only that, but
Error by terminating the SYNC proceeding, or error by what?
error by allowing the consensual guardianship to take place in the probate court and not through a consent in the child in need of care court and through the process established under the statute for that kind of consent.
So the error was the voluntary Chapter 59
Yes, because
guardianship.
exactly. When you move into voluntary guardianship under Chapter 59, you change the entire framework of the appeal process. You change the test, the legal test. I'm sorry.
But isn't that what we have?
Yes, that's what's happened. So I do ask this court, and I'm sorry.
The petition for appointment of a guardian and conservator, I at least could not find any reference to a statute to indicate that it was intended to be what chapter it was intended to be filed under. But is it just because of who the petitioners were, and the fact that they filed it as a petition, that slots it over into chapter 59 automatically?
And that's what's happened because it was labeled probate 38, 2010 PR 38. When this came to appeal in 2016, the natural parents,
So that's a
Took the-
clerk's designation.
yes,
So just because the clerk designated it by a PR case number, it ended up being treated under that chapter.
that's exactly right, Your Honor.
But not necessarily because that was the way it was petitioned or that the court order was entered.
I'm unclear about how exactly it was petitioned. If the intent of the petition was possibly probate, but my argument in that case, even if it were, would be that that would be outside the framework of the necessary steps that were needed in child in need of care, and that case should not have happened in that framework under that chapter at all. And I would ask this court that the remedy for such a situation would be to incorporate the consent into the child in need of care.
Except there's no child in need of care case. It's been terminated, right? So how do we do that? I mean, do we just have the inherent power to reopen something when it's been terminated? Isn't it the states? The state would come forward, not the parties. So how does that happen?
Although ordinarily
I understand your remedy. But I don't see. Explain to me how we get to that remedy.
Well, I don't believe, at least under the two younger children's cases, they were formally appropriately terminated through order and journal entry.
I'm sorry, they were or they were not?
They were not.
They were not.
They
The
were
two
not.
youngest were not.
I do believe, and I would question that the journal entry of review hearing as set for the older child who is still a minor in the case today, that happened in March 7th of 2011, that the language of that particular entry is broad enough that you could incorporate the intent to be that the permanent custodianship was meant to happen in the child in need of care case. This court could extrapolate from the child in need of care steps that after the adjudication happened, after the disposition happened, and the use of the probate court to consensually agree to a permanency, that permanency came back and was incorporated into the child in need of care cases as an actual order of permanent custodialship, which is allowed under the statute even without a finding of unfitness.
And again, doesn't the statute then require annual reviews? That hasn't been complied with. All the kind of statutory protections that are necessary in a St. case hasn't been complied with since the termination.
They have, actually.
How?
Under the guardianship case, you will find that there have been reviews and reportings as if they were reporting on the guardianship of a custodial minor.
To who, reportings to who and how
To
often?
the Wilson County Probate Court.
But that's under the probate code. I mean, even if they weren't minors, if they were adults, isn't there a provision in Chapter 59 for guardians and conservators to make an annual report?
Yes. And again, because of the nature of guardianship, you're going to have a lot of overlap between the probate rules and the child in need of care rules. But because the errors created by the lower courts that seem to have moved this into a probate matter, the only way for this court to substantively serve justice is to push it back into this Sink case.
And then what happens then?
Then the court could extrapolate that the final orders of the Sink cases were the incorporation of the guardianship from the probate matter as a permanent custodialship under 382272.
Before you sit down, what do you think our standard of review is on this case? The Court of Appeals applied an abuse of discretion, at least when it discussed the extraordinary circumstances. And I'm not quite certain if the Court of Appeals found that there wasn't extraordinary circumstances articulated, or the court abuses discretion in making the finding that it was so. But what do you think our standard of review is on this?
Just 1 second, Your Honor. I had that for you. I got out of order.
Justice Rosen, is that something we could ask her to look for?
Sure.
during
Yes,
the
can I
program?
cover
No,
that in
that's
my
fine.
rebuttal? I
It's
appreciate
important. There's several different standards here. We have the abuse of discretion standard, which kind of plays into extraordinary circumstances. It's also used in best interests. The district court found clear and convincing evidence of the need of a guardianship. So just be prepared to kind of answer some of those questions. That's fine.
And can I go back to your comments about the 2011 order for the older child? And you said there was broad language. I just want to make sure I know what the broad language is you're referring to. Is it the sentence in the order that says the child is released from SRS custody, proceedings are terminated, guardianship is granted in the PR case?
Yes, yes.
Okay.
May it please the court, I can't believe I'm hearing what I'm hearing being proposed here. I think this would be a travesty.
Before
if
you continue with that argument, for the benefit of people in the audience and watching on the computers, if you could once again announce who you are and who you represent.
John Gillette from Chanute, Kansas. I'm representing the natural parents, Sam Hickson and Alicia Dolly.
All right, now proceed.
I was attorney and present throughout this entire thing from the very beginning. I'm the only one left that was there for this stuff to be occurring. There was a family agreement for this to be handled the way it was handled. I don't know how we're going to be turning a probate case into a sync case or changing everything from what it was. That's not the way this all went down.
Can you have a family agreement to terminate a child in need of care case after you have a judicial determination that children are in need of care? Is that a matter of the parties making their own family settlement agreement?
Well, it was worked out, and the court was okay with doing what they were doing because it was supposed to be a temporary thing. And then when the natural parents had things resolved in regards to their criminal case and were essentially stabilized, that they were going to be getting the children back.
How is it going to be a temporary thing when they're facing incarceration and facing a sync case where a permanency plan would at least been reviewed and they wouldn't have had contact with the kids at least during the time period of their incarceration? How is that a temporary thing?
Well, there actually was contact with the children during the time. Certainly Samuel Hickson was incarcerated. That's what families work out sometimes, and that's what occurred in this particular situation. And obviously Judge Saxton, who was sat on the bench for a long time, I have the greatest admiration for him, had a lot of cases in front of him. Obviously the evidence for the court is that these cases, the same cases, were to be dismissed, and I don't believe that they actually exist at this point in time. I'm still trying to wrap my head around how on earth this argument is that, well, we're gonna, all of a sudden, this is supposed to have been some permanent thing in the Sink case when that was never the case. This was set up the way it was in the probate case, and it had been handled that way. I'm also concerned about other things. In the brief that has been filed by the guardians and conservators at page 11 and page 15, it specifically states that my clients were found to be unfit. That is absolutely untrue. There was never any termination of their rights. There was never ever any intent to have any termination of their rights. When you're looking at these things, and I learned this from a very good chief district judge, in looking at things, sometimes the shadows tell the tale. And if you look at what's happened and then look at the shadows that they cast, you see what has gone on. And in this particular case, you have a situation where the sink cases are being dismissed, you have the probate case filed, you have interaction between the guardian and conservator, who was a cousin to Sam Hickson, and it was a situation where they were ultimately supposed to be getting the kids back. And I don't see how you turn a sink case or a probate case into a sink case and start doing these other things. There was no permanency hearing held in the sink cases. Those cases were dismissed, or certainly to be dismissed.
Well, that was avoided by the probate case, wasn't it?
And that was the reason for that, yes.
What the district court found, at least maybe found, the Court of Appeals disputed extraordinary circumstances here. Would you speak to that? What? And you're relying on the Williams case, and the Williams case clearly was designed to be a temporary financial need kind of situation, 6 months or so, and described that in that situation parental preference takes precedence in all situations unless there's extraordinary circumstances. And didn't here the district court find extraordinary circumstances? I mean, there's several different findings the court made, and why did the district court abuse its discretion in finding that?
I don't believe that those actually were extraordinary circumstances. And there's never been any appellate court decisions.
In Williams, there wasn't a child in need of care case where the children were found to be children in need of care. It was designed to be temporary while the mother kind of got back on her feet. Here, there's findings that there was a child in need of care, the length of time of the guardianship. There's all kinds of and other factors that were weighed into finding this to be an extraordinary circumstance, so the probate court could then weigh the children's best interests. What's wrong with what occurred here in doing that? Because that's functionally what happened in the probate case.
In the Zink case, that was entered into by agreement for that finding, but that doesn't mean that their rights were ever terminated. While that you can argue the presumption, the fact.
Wait, the Sink case, the adjudication of child in need of care was an agreement? You're talking about the guardianship being an agreement?
I'm talking about the Sink cases as well.
Okay.
I mean,
The agreement of termination or agreement? What was the agreement in the Sink case that you're referring to?
That they would go ahead and do at the time that this was occurring, they would go ahead and agree for that to be occurring as far as them being found to be children in need of care, but that doesn't mean that the parents.
That adjudication was uncontested by the parents, is that what you're telling us?
Yes.
Okay.
But that doesn't mean that their rights were ever terminated.
No, I understand that, but that's a different circumstance that makes this unique as opposed to Williams, where a guardianship's set up for the more typical reasons of a guardianship.
Well, I'd also rely on, and it's in my brief in regards to NRA LMH as well. And this seems to be a fact pattern that's almost duplicative of that. My clients have gone to great lengths to get established. They did their stuff with the criminal cases. They had no motions.
What prevents the probate court from getting to the best interests of the children in lieu of, we have the parental preference doctrine that you have to abide by unless there's unique or extraordinary circumstances. The probate court found extraordinary circumstances and then weighed the best interests of the children in light of this motion. What's
The best interest is a sink case type thing, as opposed to a probate.
I understand. Yes, I understand that. But the probate court can weigh the best interests if they're shown to be unique or extraordinary circumstances. And isn't this case, or doesn't this case present extraordinary circumstances? So the probate court then can weigh best interests, which is what it did here.
Well, I disagree in regards to this being extraordinary circumstances. Again, part of this is a matter of what the parties were agreeing to back at that time. This thing has been turned completely around from the way things were supposed to be, and I have a...
And the reason that's happened is because the allegation of your opponent is that the children's lives have been turned around for the better.
I'm sorry, ma'am, I couldn't hardly hear you.
Okay, let me speak up. And the reason that everything's turned around is that it's the allegation of the other side of this case that the children's lives have been turned around for the better since the guardianship. And so what my colleague's trying to get you to address is why the facts of this case don't fit the extraordinary circumstances rubric.
It goes back to an agreement. If there wasn't ever any evidence ever presented about, certainly in the sink cases, of what you'd be calling extraordinary circumstances. We can argue the stuff as far as the probate case and what the judge was referring to, but again, isn't that going and using a sink level on a probate case? And wouldn't it be what
the parents are saying that the best interest of their children is of no moment, is of no concern? That's what your argument is?
No, that's not what my argument is, because the parents actually were making decisions that they felt were best for the children at that time.
Which time
But
are
that's
we
a
talking,
different- it's
which
a
time
diff-
are we talking about now? At which time were they making choices in the best interest of the children? You said at that time. What time are you referencing?
After they were arrested and in custody, they were making decisions, and that's one of the reasons why they had reached out to Mr. Hickson's cousin to step in and do the probate case for a guardian conservatorship. They've done nothing but make decisions in the best interest of the children ever since that whole thing happened. Yes, they made some bad decisions, but look at the case of LMH. That person made a lot of bad decisions and was a convicted felon and ran off to Dubai and hid out and so on and so forth. Well, if you apply the same standards in the law that was applied in that case to this case, how is that any different?
What is the legal standard that you believe we should be applying for us to review what the court did here?
Are you talking about the Court of Appeals?
The district court.
It would be... the same thing that the district court talked about, whether they could apply the essential needs for physical health, safety, or welfare. And we established that that was the case, that they could do that in the probate case. I mean, that's the statutory test in regards to a probate case pertaining to guardian conservatorship.
Well, there was some discussion a few minutes ago about extraordinary circumstances and whether they existed, and then I think we moved on from there about the best interest of the children, and you were telling us that the parents had done things in the best interest, but the district court found against that position. So how do we review that determination?
The parents agreed to agree for there to be the sink finding in the sink cases. They did not contest that, but there's also never been any termination of their parental rights. There was never anything done in the sink cases for purposes of terminating their rights or severing their rights. Had what they were talking about, what they're arguing, wouldn't that have been occurring in that case? But it was not. And you had the probate case, which they had agreed to, and there were the provisions there. And when you get to those statutory tests in the probate case, the physical health, safety, and welfare of the children, my clients have met that burden. And that's why it was an abuse of discretion there's never been any other appellate decisions that I'm aware of that have ever defined what that means.
Well,
So
Counselor,
From what you just said, are you telling us that the district court who made this determination abused his discretion because you disagree with his application of the statutory test? I'm just trying to nail down.
Yes.
That's what you're saying, okay.
Yeah, because you look at what the specific statute is, it sets out what you're looking for in the probate case. The health, physical health, safety, and welfare, and that's what the Court of Appeals looked at.
Well,
and I agree with the Court of Appeals approach.
I'm reading the opinion a little differently. You know, an abuse of discretion is either one, no reasonable person would have reached that, or two, there's an error of law, or three, that it's based on facts that are not true. And what I got from the opinion was that the failure to apply the parental preference doctrine under the circumstances of this case was an error of law. And so the Court of Appeals is not making a determination on could be the best parent or meeting any standards of care, but based simply on parental preference gives your clients custody unless there are exceptional circumstances that you could get into that other area. And so what we've been trying to get at is why wasn't the error in the Court of Appeals decision its failure to find exceptional circumstances to get away from the parental preference doctrine?
Well, again, my clients established things that in a probate case are the basic elements that you look at of whether or not people can take care of their children. My clients established that it was uncontroverted about their jobs, their homes, how they were doing financially. They've been paying this $20,000 a year in child support on these kids. They have worked hard. They've had no more problems of any kind. In fact, Alicia Dolly worked 2 shifts yesterday in order to be able to be here today. Sam Hickson works on a fishing boat out of the state of Washington. He's never missed a court appearance. They've been drug tested and stuff like that when we've been in court trying this case, clean every time. When you've established those fundamental things about them being able to take care of the children, their health, safety, welfare, then the parental preference doctrine comes into play. They've got a constitutional right to have their children back. Now, if they were not able to establish any of that stuff, then that's another matter altogether. But for as hard as these folks have worked, my goodness, they should be able to have their children back.
Counsel, we've taken a lot of your time with our questions. Would you like any time to wrap up, or do you think you've made your points?
Neither of these parents was ever found to be unfit. They never had their parental rights severed. The Sink cases were dismissed. They don't exist anymore. Again, I've made the point about objecting to other counsel putting into their brief that they had been adjudicated as unfit. That's not accurate. I think the arguments about the Sink case law should be applying to this as opposed to the probate case law is inaccurate because this is a probate case. Why would you insert Sink case law into a probate case? Her arguments are that the Court of Appeals was confused. Her arguments have been that Judge Saxton really didn't know what he was doing. It was supposed to be some kind of a permanency thing instead of a probate thing. That he was meant to create something other than what was actually done. And we already know that Bailey, well, BH is no longer, he left, got out of there, he got to be 18, graduated, he got gone. He's living in the state of Washington.
Sounds like you've made your points.
May I be excused, Your Honor?
Yes, what are you asking us to do?
I want you to uphold the Court of Appeals decision in this case. I think it was actually accurately analyzed and accurately applied. If you don't, then you've essentially thrown out In Re LMH, which that was a case I was involved in as well. If that law was good to be applied in that situation, why is it not good enough to be applied in this situation unless you guys are going to change the law?
All right, thank you, counsel.
May it please the court, I'd like to address the standard of review in the case and then move on to the extraordinary circumstances and the district court and appellate court rulings. The standard of review for the appellate court to have applied to the district court ruling of extraordinary circumstances would have been absence of abuse of discretion v. State v. Ward. And also Bolander, that the appellate court should have given deference to the decisions made by the trial court, the trier of fact, that that evidence should have been reviewed in the light most favorable to that prevailing party at the trier of fact, which would have been the guardians. The abuse of discretion would have been categorized as arbitrary or fanciful or unreasonable. No reasonable person would have taken the view adopted. There was an error in the law or erroneous legal conclusions or an error of fact of substantial or competent nature that does not support the factual findings.
Counsel, I have a question on that point.
Sure.
Preliminarily, do you agree that in order to sidestep the parental preference doctrine, you and your clients had the burden to demonstrate first extraordinary circumstances and then secondly, the best interest of the children in the lower court.
I do, but with the caveat in that in RC, where an adjudication had happened in a child in need of care case, there is a presumption of a level of unfitness. Not unfitness that leads to
Well,
termination.
that might be an evidentiary question as to whether or not you can demonstrate first extraordinary. I'm just trying to get the analytical paths squared away. It's extraordinary circumstances.
Yes.
And then you can demonstrate that it's in the best interest of the children for them to remain with your clients.
In a probate matter, yes.
Okay, so
Under probate code,
if that's the case, the first step is extraordinary circumstances, and the district court found extraordinary circumstances
They did.
here. Did the district court make any fact findings that undergirded that legal conclusion that there were extraordinary circumstances?
I don't believe that they needed to because he was on point of the RC case in which the legal conclusion was that when a child has been adjudicated child in need of care, that there are inherently extraordinary circumstances and you must apply the best interest of the child.
So when a child, your position is, as a matter of law, any child who's ever been adjudicated a child in need of care is from that point forward in perpetuity, there are extraordinary circumstances. Is that your position?
In relation to the same matter at hand, yes. If that child had gone to, if the parental plan had been properly preserved and gone through the sync matter, then that might not be the case. But when a child in need of care becomes a probate matter and it's never resolved as to a parenting plan, and
So,
there's
and I understand that. I'm sorry to interrupt, but just really quickly, it sounds like your answer to my question is that, in fact, the district court did not make any findings of fact, but the district court was not required to make findings of fact because there's a
legal
presumption as a matter of law.
That's correct, Your Honor.
And if we disagree with you about the presumption as a matter of law, then you're left with no findings that would support the legal conclusion that there were extraordinary circumstances.
And in that case, the appellate court and this court have the option of directing it back to the trial court.
That was my follow-up. Would we then need to remand?
To expand on their order, and explain why their extraordinary
So you would
circumstances
agree we
exist.
would be required to remand at a minimum for a factual inquiry
Yes,
if we don't have any fact findings.
correct.
And if we agree with your position on the extraordinary circumstances follow automatically as a result of the determination of the sync case, there is nothing for us to review in terms of an error. It just happens automatically. Correct?
I'm sorry, could you repeat it? I lost
I
track.
understood you to say, in answer to Justice Stiegel's question, as a matter of law, if there was a sync finding, then that automatically means extraordinary circumstances are present.
Yes, and then the applicable best interest of the child test that went through the trial court that they did explain very clearly was appropriate, and the trial court's holding should be upheld.
And what is our standard on that determination of the best interest of the child as found by the trial court?
The standard of review for best interest of the child?
Yes.
I believe it is the same. It is the district court should not be disturbed in absence of the abuse of discretion, because that was found at the district court. They are the ones who actually found the extraordinary circumstances and applied the best interest tests that flow from the extraordinary circumstances.
The guardian ad litem's brief outlines 7 or 8 extraordinary circumstances that could have been gleaned from this hearing. Besides being found children in need of care, multiple convictions, lack of meaningful contact, failure to report. I don't know that was those specific findings found by the district court, or are these just circumstances that we could glean from the hearing?
I believe they were transcription type of evidence that was offered that the court could have relied on, but maybe not reiterated in its order. And they mirror some of the standards of unfitness as put in the Child in Need of Care Code.
Thank you.
You're out of time. We have any further questions? Do you need any more time to wrap up? If so, I'll give you 30 seconds.
I would like to distinguish this case from LMH in that there was no adjudication in LMH. I would also like to distinguish that the opposing counsel has argued that the family agreement is allowed and that under the Child in Need of Care Code, the statute and the state is the parental right once adjudication has been entered as a child in need of care. Any agreement that the parents made at that point does not flow from the state's need to be the in parente of those children in need of care.
All right. Thank you, counsel. Thank you both for the arguments this morning. Court will take this matter under advisement.